Good afternoon, everyone. Thanks for joining us today. We have a great program prepared. I am going to take a few minutes now before we begin to go over the agenda. So in a few moments, I will turn the program over to Alyssa Christian from our Syracuse office. By now, you should all be very familiar with Alyssa as a presenter on our webinar. She will be updating us on the Financial Crimes Enforcement Network interim final rule that became effective last week. Next, we will have Arthi Chandan from our Buffalo office. Arthi will be educating us on the Warehouse Worker Injury Reduction Program. And last, but certainly not least, Stephanie Fedorka is with us from our Rochester office. Stephanie will be covering a recent decision from the Second Circuit, interpreting the Americans with Disabilities Act and an employer's duty to accommodate workers. Okay, I will now turn it over to Alyssa for her update.
Hi, everyone. As Carrie said, I'm back to give another update on the Corporate Transparency Act. This time, the update isn't too different from the last one I gave, but for those of you who have been following along this whole time, I wanted to make sure you had the latest, so let's get into it. On the next slide, I lay out the timeline of what happened since I was last here. So if you recall, the last time I gave you an update, I was speaking about the FinCEN and Treasury Department announcements that came in late February and early March. And in those announcements, they had promised to issue a new rule limiting the scope of the CTA to only foreign reporting companies. And they had promised to do that by March 21st. So pretty late in the day on March 21st, they did follow through and issue this new interim final rule. And they did narrow the scope of the CTA to only foreign reporting companies. If you recall, the last time I was here, I had to speculate a bit because we didn't have the actual rule to know what the new rule would be. And so now I have those details and I'm planning to go in depth on that with you today. But first, we need to go over what is a foreign reporting company. And then just so you know, foreign reporting companies will have until April 25th to file if they haven't done so already, or if they have any updates from a previously filed BOI report, they will need to do that by April 25th. And any newly registered foreign reporting company will have 30 days once they receive notice of their registration being effective in the United States. So just to illustrate that a little more, let's talk about what a foreign reporting company is. So this definition has not changed under the new rule, but it's just really important now since this is the only type of entity that the CTA applies to. So first, it has to be an entity that's not formed in the United States. And the second requirement is that it's registered to do business in the United States. So as I said before, if this is a foreign reporting company that is just registering to do business in the United States, it will have 30 days from the date that it received notice that the registration became effective. It's important to note that just because the received notice doesn't mean that's the date. If it's in a state where there's a publicly viewable database, if it was listed on an earlier date, that would be the effective date. So it's actual or constructive notice. But as I said, this part of the definition has not changed under the new rule. So foreign reporting companies' reporting requirements are largely the same. The one notable difference I have outlined on the next slide is in regards to their beneficial owners. Under the new interim final rule, foreign reporting companies do not need to report any information from any US persons. So under the old rule, if a foreign entity was owned by a US person, that BOI report would have included that US person's information. Since FinCEN is now limiting the CTA requirements to foreign reporting companies and does not want to burden any US citizen with this, the foreign reporting company can now leave off any US person that's a beneficial owner. But I do want to point out that just because they have US persons as beneficial owners does not exempt them from the reporting requirement. The foreign reporting company will still need to file a report. And in the event that they only have beneficial owners who are US persons, the filing website has now been updated to add a box that says, check if all beneficial owners are US persons, which will then allow you to submit the report without giving any information on beneficial owners. On the next slide, I have some illustrations here to, go over what I just talked about. So under the old rule, US companies, most of them were considered reporting companies. Under this new rule, a US company will never need to report. So on the left, we have a US company that is owned by all US persons, does not need to report. Even the illustration on the right does not require any reporting, even though it is this company is owned by foreign persons. On the next slide, I get into an illustration of what it means. So a foreign reporting company, this is a company that is formed outside of the United States and is registered to do business in the United States. Because it is owned by foreign persons only, all of their beneficial owners need to be reported. So this company would need to go through the analysis to determine who is a beneficial owner. That has not changed. So 25% or more of the ownership interest or substantial control, any of those people need to give their name, address, a copy of their ID, and the reporting company also needs to provide its name, address, taxpayer identification number, and DBAs and such. Where the new exemption gets a little tricky, I have illustrated on the next slide. So here we have a foreign reporting company that has both foreign persons and US companies, a US company that is owned by a foreign person. So under the new rule, a US company is listed in the exemption list. The foreign reporting company will still need to file a report. The foreign person who's a beneficial owner of the reporting company will need to provide their beneficial ownership information. However, anybody who owns their interest or is a beneficial owner in the foreign reporting company through a US company would be exempt, and this is regardless of whether they're a foreign person or a US person. So on this diagram, I tried to lay that out. A situation would look like this, but if you have any questions, please feel free to reach out. And then I have two more illustrations, I think. So on the next slide, this is another example of what I had said before. It's a foreign reporting company. It's only owned by US persons. So in this situation, the foreign reporting company would file the report, give their name, address, DBA, but it would be able to check that box that says all beneficial owners are US persons. And then finally, I have one more illustration similar to what I had said before. It's a foreign reporting company must report. Still does not need to give any beneficial owner information though, because it's owned through a US company. And so those are all the illustrations I have, but just want to point out a few more things. The foreign reporting companies do have an ongoing duty to update. That's nothing new, but again, if anything changes that's on the report, you have to file within 30 days. This is an interim final rule, which means that it became effective once it was published in the Federal Register, which was a few days after it was released. But there is a comment period, so there might be some small changes to it. And we don't have any new information regarding the US companies who have already filed their identifiers. So that's all I have. Oh, and the New York liability is still in effect. It hasn't gone into effect yet. That will be next year, so I'm sure I'll be back. Give you an update on that. But again, please reach out with any questions. This might be it for our little CTA saga.
Thank you, Alyssa. Yeah, I know you've been on the webinar quite a bit recently, so You may have just alluded to it there, but do you think there will be any other big changes to the Corporate Transparency Act in the near future?
Yeah, Carrie, so that's a good question. There are still court battles that are going on, and there are still bills in Congress, regarding the future of the CTA. Even this new rule could be challenged because it's such a broad exemption. It's just very unlikely that there will be any reimposition of the filing requirements on US companies anytime soon. So if I had to speculate, I don't think US companies will be required to comply. Although I've been wrong before, and if that happens, I certainly will be back to give everyone an update on that.
Okay, thank you. Yeah, that's good to know. We appreciate your insight as always. Arthi is up next to talk about the Warehouse Worker Injury Reduction Program. Arthi?
Thanks, Carrie. So as Carrie mentioned, I'm here to discuss the recently passed Warehouse Worker Injury Reduction Program. This amends New York Labor Law, Section 780, and it takes effect on June 1st of this year. This new law requires warehouse employers that directly or indirectly employ at least 100 employees at a single warehouse distribution center in New York State to develop formal injury reduction programs, to train employees on ways to reduce injuries, and to work with their employees to help identify and minimize the risk of musculoskeletal injuries in the workplace. So some of you were thinking this sounds kind of similar to certain OSHA requirements. And additionally, by June 19th, covered employers must enlist the help of a qualified ergonomist to provide an evaluation of risk factors that cause or are likely to cause musculoskeletal injuries. So you're probably asking yourself, am I a covered employer? What's the definition of covered employees under this legislation? So the definition of an employer under New York Labor Law 780 states that an employer is a person who directly or indirectly or through an agent or any other person, including through the services of a third-party employer, temporary services or staffing agency, independent contractor, or any similar entity, employs or exercises control over the wages, hours, or working conditions of 100 or more employees at a single warehouse distribution center, or 1,000 or more employees at one or more warehouse distribution centers in the state of New York. So we can look to the definition of employee to determine precisely the type of employee contemplated within the meaning of the quote 100 or more employees. So, based on the plain text of a legislation, an employee is categorized as someone who, 1, works at a warehouse distribution center, 2, is not exempt from minimum wage and overtime provisions, 3, is subject to a quota, and 4, is not a driver or a courier. The legislation also delves into the definition of a quota, which I'm sure you've heard come up in the context of another law that was recently passed called the Warehouse Worker Protection Act. They define quota as a situation where an employee is assigned or required to perform at a specified productivity speed or a quantified number of tasks, or to handle or produce a quantified amount of material within a defined time period. So, an employee is someone who must be subject to a quota requirement that is, 1, a speed or quantity-based quota. So you have to do this amount of tasks in this amount of time, or, a quota that differentiates between performing and non-performing tasks. Both quota definitions require that an employee may face negative consequences for failure to meet such a quota. Notably, a chapter amendment was introduced in February by 2 senators, Jessica Ramos and Harry Bronson, and it permits a broader class of ergonomics and industrial hygiene professionals to review such worksite safety plans and to ensure employee-led safety committees are empowered to elevate their concerns regarding ergonomic safety concerns in the workplace. So this chapter amendment was signed into law by the governor, and it redefines what a qualified ergonomist is. And specifically, it redefines the standard as a competent person standard. So really, this amendment broadens the class of professionals that an employer may use to comply with this law. It also broadens certain classes of injuries and processes under the law to the benefit of the covered employers. So another question you're probably asking is what is an injury reduction program? What this is supposed to do is it's supposed to identify and minimize the risk of, as I mentioned, musculoskeletal injuries and disorders among employees involved in performing, quote, manual materials and handling tasks. So there must be 5 components included in a covered employer's injury reduction program. So the first is a worksite evaluation. The second is a control of exposures, including PACE, that have caused or have the potential to cause musculoskeletal injuries and disorders. The third thing is employee training. The fourth thing is on-site medical and first aid practices. And the fifth thing is employee involvement. And I think that's really important to note that employees have to be involved in this process. So, as I mentioned earlier, this kind of all comes in the background of another law that was recently passed called the Warehouse Worker Protection Act. Similar to the Warehouse Worker Injury Prevention Program, it requires employers at warehouse distribution centers to disclose any of those quota systems that I mentioned and to monitor and track discipline that warehouse workers face for not meeting these quotas. And, the aim of that law is to ensure that warehouse workers are aware of the standards used to evaluate their performance. So, this all comes in the background of, I'm sure we've all noticed a lot of Amazon warehouses popping up or, other warehouses that are associated with grocery store chains, for example. And, the lawmakers who have proposed, these 2 laws, they note that, work speed quotas and these fast-paced environments in warehouses kind of worsen the injury-prone nature of these types of jobs. So, 5 states so far have enacted limits on large warehouse operators, such as Amazon's use of performance mandates, that they define as quotas. And additionally, OSHA announced a nationwide emphasis program that started in 2023 that focused on improving safety in warehouses. So this has kind of been developing for a couple of years now. As I mentioned, the law doesn't take effect until June 1st, but it's important for covered employers to start developing these warehouse injury prevention programs proactively so that you're not coming up on the date and you're scrambling on it.
Thank you, Arthi. Can we expect the state to issue guidance on the injury reduction program or release a model injury reduction policy?
I would say yes. We've seen in the past that as the effective date comes closer, the state typically, at the very least, will release some guidance, possibly a Q&A. I would also expect them to release kind of a sample injury reduction program so that employers aren't completely in the dark and are aware of how these things are supposed to look.
Okay, great. Thank you. Yeah, we still have a few months until the law goes into effect. So, okay, I will now turn things over to Stephanie for her discussion on the Second Circuit's decision. Steph?
Thanks, Carrie. Always great to be on the webinar, folks. Thanks for joining us today. Kathy, you can advance to the next slide, please. Today, I'm going to be talking about a quick development in our jurisdiction. So just for purposes of reference, we're talking about a Second Circuit case. The Second Circuit is a federal court that governs law over New York, Vermont, and Connecticut. It's a federal court. There are district courts. There's 4 in New York, 1 in Vermont, and 1 in Connecticut that make up the Second Circuit. So those are going to be those initial courts where if someone has, those are the common courts or the most common courts that we see where someone has a claim of discrimination. They're going to be bringing those more oftentimes than not, in my experience, in those federal courts. So this is an appeal decision. So I just wanted to give some of that context for those who may not necessarily be familiar in terms of when we're talking about the Second Circuit, what does that mean? How is that significant to what we're doing here in New York? So on March 25th, the Second Circuit significantly changed a legal standard that it was applying for employers regarding disability-related accommodations. To give you, again, a little bit of background, prior to this decision, employers could win on either a motion to dismiss or motion for summary judgment, which is just a fancy way of saying, or a legalese way of saying that before having to go to trial, right, without having to go to a full trial, an employer could win and get a failure to accommodate claim dismissed, where the employer could establish that the employee could perform the essential functions of their job without an accommodation. In other words, if an employee did not need the accommodation, that was an argument that could be advanced and that could win to get one of those types of failure to accommodate claims dismissed. Next slide, please, Kathy. So some of the facts of this case. So there was a high school math teacher who had a long history of PTSD. The PTSD was related to sexual harassment in the workplace. It's not necessarily relevant for purposes of our discussion or the application of the law here, but I wanted to give that fact as an interesting fact because I do think that maybe there was something considered by the Second Circuit along those lines. So she had PTSD for a long time. She had severe symptoms, including a stutter that affected her ability to communicate. She would have nightmares that disrupted her sleep and would cause vomiting when she would wake up and vomit. So very, very severe symptoms of PTSD. She took medication as well to manage a lot of her symptoms, and she had been previously admitted to the hospital for psychiatric care 3 times. So the school district that she worked in had previously approved her to take 1 15-minute break during each morning and afternoon during her prep period in order to help manage her symptoms. So she would leave campus, if you will, go and do something for 15 minutes and come back. There was a change in administration in the building or in the district, and they came in and ultimately implemented a new rule that prohibited teachers from leaving campus during prep periods. So the teacher subsequently tries to leave campus during one of her prep periods pursuant to her previously approved accommodation, and she ultimately was reprimanded and told that her documentation on file was insufficient. During the process of this lawsuit, the teacher did admit that she was able to perform the essential functions of her job regardless of the denial of the accommodation. In other words, she was able to still teach even if she didn't get these 15-minute leave campus breaks, if you will, in the morning during her prep periods or in the afternoon during her prep periods, even though it was difficult for her, but she was still generally able to perform the essential functions of her job. Next slide, please. So ultimately, the district filed a motion for summary judgment, right? Tried to avoid going to trial, and this in the district court. So this one was coming from the Northern District of New York. The district court granted that motion for summary judgment and said, yep, we agree. The teacher did not need this accommodation. And so the district is entitled to dismissal of those claims, and there's no need to go to a trial. So the teacher appealed to the Second Circuit, and the Second Circuit reversed that decision. It reversed the decision and vacated that decision and said, go back to the district court to do it again, essentially, or to continue the process in the litigation. The district court said, the Second Circuit rather, said that the district court had erred by holding that an employee's ability to perform the essential functions of her job without a reasonable accommodation is fatal to her failure to accommodate claim. And so when it did that, it really read the text of the ADA literally and strictly, and looking at the definition of a qualified individual, right? A qualified individual is someone who is entitled to an accommodation under the ADA. So qualified individual under the literal words in the ADA is an individual who, with or without reasonable accommodation, can perform the essential functions of the employment position that such individual holds or desires. So the Second Circuit said that the ability to perform the essential functions of the job is relevant to the failure to accommodate claim, but it's not dispositive, meaning it doesn't seal the deal. It doesn't say that just because they can perform the essential functions of the job, that the employer wins and that the employer's obligation to accommodate that person is done at that point. Next slide, please. I think it's interesting to note as well that this is not necessarily new or earth-shattering. It is for the Second Circuit in the sense that this is a new Second Circuit court precedent, but the Second Circuit in applying this rule that need is not a requirement for reasonable accommodation. It joins other federal circuit courts, including the 1st, the 5th, the 6th, the 9th, the 10th, the 11th, and the DC Circuit Court in applying this type of legal analysis to those types of failure to accommodate claims. So the key takeaway for employers here is that employers must, absent undue hardship, offer a reasonable accommodation to an employee with a disability, even if that employee is capable of performing the essential functions of the job without an accommodation. So this is a really good time to review your current accommodation processes. And I always recommend training and educating supervisors or anyone else in your organization that's going to be interacting or evaluating these accommodation requests or part of that interactive process on both proper protocol for the interactive process. What you can and can't ask for is always a good thing to make sure people are educated on, so they're not saying the wrong things or asking for the wrong information, as well as how to evaluate those requests for accommodation. So just because an employee is able to still generally do their job and perform the functions of their job without the accommodation, that doesn't mean that your job as the employer through this accommodation process is over. You may still have to evaluate whether there's an accommodation that might be able to help them and ease the way that they do their job. So don't forget to engage legal counsel for assistance when evaluating these types of requests. They're very, very fact-specific, case-by-case analyses. So if you're confused, if you are not sure whether or not that you can deny or should deny, or how you should respond to a particular request for an accommodation, it never hurts to get a legal counsel involved early on, because we're able to help you navigate those things, give you good advice, so that at the end of the day, right, these are really tricky and fact-specific situations, right, that always will carry some risk. But ultimately, you want to make sure that you're informed. You want to make sure that you're confident in whatever your decision ultimately is.
Thank you, Stephanie. We appreciate the update. Yeah, as Stephanie mentioned, it's important for employers to consider this decision when engaging in the interactive process with employees. And perhaps this is also a good time to make sure that your organization has a solid understanding, as Stephanie said, of the ADA and the New York Human Rights Law accommodation process, because it can be quite nuanced. And again, we're always here to help navigate the process should you have any questions. Thank you again, everyone, for tuning into the webinar today. We have the contact information for all of today's presenters on the slide right here. Please feel free to contact any of us with any questions. Gabe will be hosting the program for the next 2 weeks, but I will be back on April 22nd. I look forward to seeing you all then. If you're available, please tune in to the webinar next week. Have a great rest of your day. Thanks so much for joining.